Good morning, everyone. My name is Berger. I'm the convener of the IBF, Independent Beneficiaries Forum, and we are glad and proud to be partners with and co-hosts with Wits today, and we're glad also for the support of Recreate. Just want to speak about the purpose of this event. I'm sure you've seen, you've heard, people got so divided. You've had conspiracy theories, you've had mudslinging, you've had people not talking to one another anymore just because we are amending our laws of 1978. So to put a perspective to it is that we've got to change our laws. They're too old. And the question is it a process that has been properly done? And there's a question about consultation and all of you. But I think because of the divisions that have been happening amongst us as industry, I'm particularly from the creative sector, music to be particular, but the publishing industry, your creative sector, your education. So this is not about just one sector, but it's about all of us to ensure that we've got the bill that will grow this country, will grow our industry.
Now they want to put you to wear a belt.
In terms of why this came about, breaking the impasse. At some point I've been thinking of this kind of idea to partner with Wits. And I called the presidency and I just wanted to find out where is the president with this, because he's been having this bill since March last year, and nothing has really happened. So, but the first statement I got is that you guys are so divided on this, and actually the president is not interested in taking sides. Not your side, not either side. And actually I was even more encouraged to organize this dialogue in partnership with Wits, of course, and Recreate, and Sean Flynn out there, as organization to say, how can we break the impasse? I think fact of the matter is that the president is the only one with the prerogative whether to assent to these bills or to send them back to Parliament. So we've invited, and I have to put it on record, the guys who have been opposed, very opposed to the bill, who have been very, very robust in opposing the bills, to say it's not fit for purpose. But at some point, I think they took it very personally because of some of them are here. I'm glad they are here on their own individual front, but as an organization, as a collective, they decided not to participate. It's not a train smash because it's not for us to influence the president, but to keep talking. And I always say to my friends in the creative sector who think that I'm selling out by supporting the bills, to say we're actually better off with these bills than the status quo. And I said to them, if the president assents to the bills, we still have to work together as an industry to actually lobby, particularly for the right regulation framework that will make these bills work, and for extra lobbying of the further amendments at whatever point. If he doesn't assent, we'll get the same opportunity, but we still have to work together. So I want to say welcome to you all, and I'm hoping for a robust engagement, and don't be shy, speak your mind. Any conspiracy theory is welcome, as long as you can back it by facts. Thank you so much. Thank you. Okay, I've got a task and a duty that I'm not very used to. I need to introduce my friend, my comrade. This is a woman. I always say, when I speak to MPs, I always say, how do you work with Joan Fubbs? I mean, she's got vavavoom. She never retires, she refires. And they say, this one, she's a slave driver. If you're part of a committee, you're not going to sleep. She'll want reports even at night. Mrs. Joan Fubbs has been actually very close to this process. We've got a new portfolio committee now, but she actually was chairing the previous portfolio committee in the fifth administration that actually dealt hands-on with the two bills that we're going to be engaging on. So, Mrs. Joan Fubbs, I welcome you, and thank you, and give us something to think about.
Do you want me to stand, switch on, or?
Technical,
you want me to talk from here? All right. Good morning, everyone. And particular thanks to the organisers of this Indaba. And it appears as if it's a cooperative affair, the organising of this. But just to mention those whom I know were directly involved, and that is, in fact, Teboho Satatu, who introduced me from the Independent Beneficiaries Forum, but also, of course, Denise Nicholson, who is the Scholarly Communications Librarian here at Wits, Justice Zach Yacoob, Advocate Jonathan Berger, and to the institutions who are here, the heads of institutions, especially one of my alma maters, the University of Wits, who has also facilitated this Indaba. We have panel experts and participants and moderators, academics. We also have authors and creators. In fact, all the stakeholders who have some involvement are here with us, I hope. I believe a broad range of stakeholders were invited, but like the wedding feast, not everyone came. And fortunately, unlike Jesus Christ, I believe they didn't have to go into the hedges to get the current participants, but that they actually have people who are interested, including the presidency itself has sent some representatives, and I believe there are delegates from departments, the United States Embassy, and so on. So it does seem as if those who really would like to enlighten themselves are with us this morning. So all protocol observed. If I have forgotten a very important person, please note my apologies in advance. And what I like now is the new approach. You don't come and give a lecture. You come and have a conversation about an issue. And as the current Indaba says, it's focusing on breaking the impasse, the Copyright Amendment Bill Indaba. And all I'm going to do is share a few views with you. I'm not coming here to make pronouncements. That is not my role with you this morning. But because you're talking about breaking the impasse and the references to some of the challenges, concerns, and fears that have been raised, have been, many of them, constitutional or tagging. So I do want to contextualize the Copyright Amendment Bill within the Constitution, because the Constitution is our first instrument of transformation. And if we accept that, it inspires us to aspire to an ability of purpose and to walk forward so that we all hold our heads high, all South Africans, not one small section of our society. But having read so much about the fears and the concerns, and even seen some in writing, I would like to ask you to share with those who are not here today that we all need to have the courage to conquer our fears. If we do not conquer these fears, we will not progress. And whether we like it or not, progress comes marching along. So many of us couldn't even imagine the Berlin Wall falling. And it fell, quite unexpectedly. Many of us couldn't even imagine another kind of South Africa outside of an apartheid dispensation. Now we have it. So it's clear that courage of convictions and purpose overcomes fears. But at the same time, one also reminds oneself, one is talking about copyright. Have there been any other challenges along the way? Well, there have been so many, I really don't have the time to share them or to encourage you to recall them. But you will all have heard of the Gutenberg press and the hoo-ha that didn't create, purely because it was going to enable so many, many, many more people to read and enlighten and educate themselves. And it came about, that's gone by, and so on and so forth. But something else also should inspire us. I'm really pleasantly surprised at how many people welcome the Constitution, especially our new Chief Justice, Mogoeng. And just recently, I believe last week, he said, last week, yes, that, you know, the Constitution inspires us to fulfill our dreams because our highest aspirations are contained therein. And he referred to, of course, issues such as equality, non-racialism, non-sexism, improvement in the quality of life in each citizen, and freeing up, and that's why many of you are here, freeing up business, educational, artistic, musical, political potential of each person. That's what the Constitution does for us. It enables us to fulfill our potential. And indeed, if we open up our minds, we will be able to see that this is the intention of the Copyright Amendment Bill. But before I continue, I do not have papal infallibility, and neither does Parliament. And that needs to be said. Having said that, let me continue. The Constitution and the copyright tries to bring about an inclusive society. How does it do that? By sharing its knowledge. The clauses contained therein will enable and underline a greater free flow of information. We do know from our own experience of the past that only in a free and democratic society is creativity and innovation nurtured for the benefit of all in society. This Indaba offers us an important opportunity to foster dialogue through conversation. The problem with just dialogue is when you're in dialoguing everywhere, you're thinking more of what you're going to say, rather than listening to what the other person is going to say. And in a conversation, you have no choice but to listen in to what the other person is going to say in order to respond intelligently. So here at this conversation that the Indaba has facilitated, I'm hoping that the imbalances in the prevailing copyright, because the Copyright Act of 1978 prevails as we sit here, that this conversation will enable us to appreciate those imbalances and to fairly conclude and resolve whether or not the amendment bill, the Copyright Amendment Bill, is able to effectively deal with this. One of the contentious issues in the Copyright Amendment Bill is the exclusive rights. But what we all know, even if we are not lawyers, no right is absolute. Thus, the exceptions and limitations are essentially put in place to balance the rights granted to authors of copyrighted material with the public interest of society at large. The other point that we want to deal with is the concern raised on fair dealing, fair use, and this. And I heard just in passing in Johannesburg recently that part of the problem is that it brings about the collapse of publishing houses. It'll kill creativity because no musician will originate another piece. There won't be another composition because there will be no protection. Well, I'm sure we're all aware, those of us who are musicians, those of us who are artists, and those of us who are writers, that we have all learned from the past, from those who have previously composed and written and painted and sculpted. Because it is through these great artists that we learn. In fact, you know, the old apprentice 500, 600 years ago, 700, would be encouraged to copy the master's work in order to try and perfect his own. So this has been with us always. But more and more, we appreciate people also, those who produce these works, should also benefit financially. So we do not want to have an imbalanced approach to the matter. And that is why the Constitution affirms that, as does WIPO. The WIPO Copyright Treaty affirms the need to maintain a balance between the rights of authors and the large public interest. And it specifically refers to education, research, access to information, and so on. The other issue which we need to address, perhaps, is that the authors, writers in particular, and publishing houses say what the current bill on the table, it's not an act, but the bill before the president, is going to encourage a carte blanche for wholesale free copying. Well, I don't know, I'm going to be on the streets begging. And that's what an author may say, it's what a university person, an academic may say who prepares a paper. But we all know that that is perhaps exaggerating the point. It truly is. There are limitations here. There is no such thing as producing for your students 1,000 copies. No, does not allow for that. Or one is told that the Copyright Amendment Bill will create a litigious environment. Well, in some ways, I sort of hoped a litigious environment would have given back some of our earlier musicians some of the money they should have earned, like the Line Feeds Tonight sort of composition. But no, nobody wants to create a litigious environment in South Africa because, frankly, the only people who benefit is the legal fraternity, no one else. So we would rather see people cooperating and recognizes what each person should be getting out of this, or not so much person, institution, or whatever. The other thing, though, which the digital age has made me realize. And in my lifetime, I've come from very much a writing society, handwriting, to now the digital age and all kinds of things, and being able to call on people through these info little gadgets and say, get me this, play me that. I don't even have to be near them. And it's all happening around one. So we've come across the digital age, and no, it's not going away. It's all here to stay. Someone asked me, if you feel so strongly about that, you know, you should have maybe spoken at Google and at Wikipedia. Why are you speaking here then? I said, for the simple reason, I was chairing at the committee in Parliament, and that would have been a conflict of interest for me to take up those invitations. I am no longer chairing the committee, and neither am I a member of Parliament, but a member of the public. That's who I am. And therefore I don't have a conflict of interest. So just to reassure those who are still worrying why I was rung last night when someone heard I was speaking here, that's the simple reason why I'm speaking here. But whether we like it or not, the weightless economy is here, and that's good for us. It's good for us because it actually encourages a learning environment, a learning economy, a knowledge economy. That's where we are going in the future. But how do we protect what people are doing now? So we need a balance between the two. The other issue is that economists who've been with us the whole year evaluating whether or not we'll survive, or will our economy go down the tubes, etc., ready to junk rate us any moment. And there are perhaps some who may have this in mind when they write and plead with the President not to assent, but to send the bill back to Parliament or to the Constitutional Court. But what they need to be mindful of is whether or not we're going to be junk rated is not an issue that is within the President's constitutional obligations when it comes to assenting or not assenting. The President can only be concerned with the constitutional reasons why this bill should not go forward and be enacted. So I do want us to be mindful, and I'd like to ask how much time I have left. 2 minutes. So, given our constitutional imperatives that put people first, the principles of dignity, equity, and fairness of engagement, what we should also just point out is the tagging. The tagging, well, we have no problem. 74, everyone knows that's a money bill status. But when it comes to 75 and 76, many were of the opinion that, in fact, it should be a 76. It should have been in the provinces. The provinces should have had more influence. But the reality is, constitutionally, this is a competence of national government. But the provinces do influence the bill through the National Council of Provinces, which some may have forgotten is the first house in Parliament, which can send back a bill that the National Assembly has adopted. So you've got that check and balance. The issues, which I won't give, you can read them up yourself, but the broader sort of issues that we took care of, socio-economic development, musicians, and also the educational and the modernization, and those with disabilities, etc. But most importantly, perhaps, as I conclude, because the specialists are people sitting here and experts who are going to thresh this out in panels with our engagement, is that I know the Indaba seeks to harness the minds and skills and research of a broad range of stakeholders. And I wish you all a most constructive and productive Indaba, characterized by robust discussions, but discussions which at the end will persuasively open up the ears of some who still do not wish to take the bill forward in line with our Constitution. And I thank you most sincerely for listening. Yes.
Okay, thank you so much to Mrs. Fubbs for giving us something to think about. So I see Justice Yacoob, taking from the cue of Ms. Fubbs in terms of talking about the constitutionality of the bills, because that's where we are. I think we're gonna hear more of that, whether these bills are in line with our Constitution or if they actually conflict with our Constitution. And like we always say, this is the President's prerogative. He can only send the bills back if they are not in line with our Constitution, not whether we like it or not. And because he has got an obligation to assent to the bills. And Prof. Berger is also here as part of the panel. So this is our first panel that will zoom into the constitutionality of the bills. Thank you.
That's fine. Thank you. Who is it, John?
Good morning, everyone. I'm Andrew Rens. I have a simple but very welcome task to introduce our two panelists on the first panel on constitutional issues.
Eh? You sure?
So Justice Yacoob is originally from Durban. So for
Should
those of
maybe
you who
try and
from that
finish in
part of the world,
15 minutes at this time. They're running late already.
And he became a senior advocate in 1991. But all the while he was working for Democratic South Africa, was a member of the UDF, and subsequently during the transition to democracy, he was a member of the Technical Committee on Fundamental Rights during the negotiation process, and he became, and then he was a member of the IEC executive, the Independent Electoral Commission, before becoming a Constitutional Court judge, where he served from 1998 to 2013. So he brings to us this vast wealth of legal knowledge, but also the lived experience of what it is to be a blind person in South Africa and try to access knowledge and access learning materials and books. Our other panelist is also an advocate at the Johannesburg, so he's an advocate, like Justice Yacoob is now, but he's an advocate at the Johannesburg Bar. Jonathan Berger clerked at the Constitutional Court for Justice Cato Regan, and he worked for many years for first the AIDS Law Project and then Section 27, protecting the right to health, and in particular working around access to medicines. He's currently a member of the expert advisory group on the global patent pool, so an important intellectual property innovation, and we're pleased to welcome both of them this morning.
Okay, thanks very much, everybody. Jonathan and I have agreed that I should go quickly first. But firstly, thank you for the keynote speaker. The job of a keynote speaker is to unlock the door. And she has unlocked this door and has made it wide open for all of us to tread carefully within the space that she's opened. And I thank her very much for that. Of course, we have a constitution in our country. And the first point I wanted to make to set the scene is that this is part of the overall struggle for non-sexism, non-racism, equality, fairness, and social and economic rights. Our constitution provided for this kind of society, but our constitution didn't achieve it. What it did was that it created a new phase of the struggle for democracy. So we remain unequal, we remain sexist, we remain racist, and I say so without apology. And a lot of hard work is required to change that. There are conflicting interests. There's been an effort to balance out the interests of capital and labor by having a constitution that provides for fair labor practice. That doesn't really work too well because we don't get too much money into the country as a result. And the fight between capital and labor remains. And all we can do is achieve a proper balance. This struggle is part of that overall struggle. So let's not see it as a separate struggle. It's a very important struggle. It is a struggle in which reasonableness is not going to bring about compromise. It is a struggle in which different people have different vested interests. There is money to lose here, guys. Millions to lose here. And people don't lose money easily. There are idiots like us who do work for free, but there aren't many on this earth. And therefore, there are vested interests, there are money interests involved, there are business interests involved. And the trouble is that we need those business interests, we need to look at them to some degree and so on, but that is the overall context. It is part of that struggle. And now let's look at the president. Our constitution provides that Parliament passes the bill, either in terms of section 75 or 76, as has been indicated, and the president has to decide in terms of section 79 of the Constitution. And if you have it, it's a fairly easy section which you need to look at. The first thing to note about section 79 is that it gives the president a constitutional obligation. The president is obliged to do certain things. And part of the problem with bringing about positive change in the country is that those who don't want it, the publishers, the racists, and the sexists, and the unequal people and capital, if it is in their interests, will delay. And therefore, in section 237 of the Constitution makes it quite plain, and I do well to remind the president at this stage that section 237 of the Constitution says that all constitutional obligations must be performed diligently and without delay. So the section 79 obligation is an obligation which, Mr. President, you must perform diligently and without delay. And the only decision that the president has to make is whether he has reservations about the constitutionality of the bill. He will be doing badly if he is guided by extramural and external influences, because we understand politically that in the country today, there is a debate about wanting more investments and sweet-talking business, and if I may use the term, massaging them so that they make more investment in the country. But the extent of that massage, Mr. President, is limited. We cannot say to business, you can be as unfair to labor as you like. We cannot say to business that we will compromise the right to strike. We cannot say to business that you can pay unfair wages. We cannot say to business that you can exploit labor. And we cannot assuage business by saying to publishers, you can have your way as part of bringing about more investments into the country. Because investments would come in at the cost of this kind of problem are investments which do us harm in the interest. But in any event, what business thinks about it, what publishers think about it, what we think about it, are all factors which the president has to take into account. But he must be careful that the only decision he has to make is whether he has reservations about the constitutionality of the bill. And he needs to bear in mind that this is the first step in the process. Because Section 80 of the Constitution allows political parties to bring a matter, bring a challenge. But ultimately, anyone in terms of Section 38 of the Constitution who is adversely affected by the bill can always bring a challenge in the Constitutional Court. So the President's duty in terms of his reservations is one of three safeguards in relation to national bills. The one is his reservations. Two, political parties can take it to court. And three, people affected can and they will take it to court. So if the President doesn't sign the bill, the Constitutional Court is not going to be deprived of an opportunity, and the President must bear this in mind. The Constitutional Court is not going to be deprived of the opportunity to look at it, because somebody is going to take it to the Constitutional Court anyway, and ultimately it is the Constitutional Court we have to decide. There's one other element. The President is not prevented from signing the bill. The Constitution doesn't say you can't sign the bill if you have reservations. Far from it. Section 79 says, if you have reservations, you send the thing back to Parliament. If Parliament complies and accommodates your reservations, that is what the words which are used in the Constitution, then what you do is you sign it. But if the Constitution, if Parliament does not accommodate your reservations, you only have two choices. You're not even obliged to send it to the Constitutional Court. You have the option either to send it to the Constitutional Court or you can sign it. So you can sign the bill as President even if you have reservations and even if those reservations are not accommodated by Parliament. He is not obliged to refer the matter to the Constitutional Court, and therefore he would be right to think that there is no point in delaying this thing any further. I would rather sign the bill because people are going to take it to court anyway. And in these matters, there are all kinds of differences of opinion. And I've read the opinions. The important things to bear in mind here is that we are not a liberal society. We're not working for a society for freedom alone. We want a society which reflects a balance between dignity, equality, and freedom. Of course, the publishers would emphasize the freedom of it. The publishers would have nothing to do with dignity. The publishers would have nothing to do with true equality. The publishers would have nothing to do with affirmative action. So bear in mind that our Constitution is not about freedom. Our Constitution is about dignity, equality, and freedom. And freedom comes last in the equation. And our Constitution, the President must bear in mind, is about affirmative action. It is about ensuring that people, and not only particular racial groups, look at the second sentence of paragraph 9.2 or clause 9.2 of the Constitution carefully. It's not only about people who were disadvantaged racially or in terms of the equality provisions generally, but there is an obligation in terms of section 9.2 on the state to take legislative and other measures to advance people or categories of people who have been disadvantaged by past discrimination. And poor people, people who have had no access to knowledge, have no access to literature, have been disadvantaged by past discrimination, and therefore they need affirmative action. So there's dignity, equality, and freedom. There's freedom of expression, all of which is ignored, because all they talk about is the right to pursue economic activity, an overemphasis on freedom. So I'll stop here. I'll answer any questions as you want to, but these are generally the things that the president must bear in mind. But to emphasize that he must do it diligently and quickly, to emphasize that nothing prevents him from signing the bill, even if Parliament does not accommodate his reservations, and even if he has them, and to emphasize that it is the kind of debate that is going to court anyway, then there's no point in having two constitutional court processes, the one to determine his reservations, and the other when they take everything else to court. You might as well take everything to court at once. And the debate is very clear. There are differences of opinion, but I must say, and I can justify it if necessary, I fall on the side, quite clearly at the moment, on the side which says Section 75 was the right procedure. I fall on the side which says that the deprivation of property is not a problem because at best it is justifiable, not just justifiable as some opinions would have it, but it is wholly justifiable in an open and democratic society. But not only an open and democratic society, an open and democratic society based on dignity, equality, and freedom. So I would suggest that even the retrospective provisions, in my view, are justifiable. But that is not to say that I'm right, because in these matters, there can be legitimate differences of opinion. And all of you who are lawyers know that I have often ended up on the wrong side of the judges and have had to write minority judgments where the majority overruled me. So there are differences of opinion in these matters. But I am at this stage reasonably convinced that the bill is appropriate and proper. And in my humble opinion, the president will be failing in his duty for a number of reasons if he does not sign it diligently, and instead of the words without delay, I'll paraphrase the Constitution and say quickly. Thanks very much.
Jonathan, if you'll continue.
Thanks. It's a very difficult position to be in, to have to follow Zach Yacoob. I must say that's probably a much easier position to be in than to be in front of him in the Constitutional Court. Luckily or unluckily, I never had that privilege. I was there as a junior. I never spoke. I want to start with picking up on the point that this matter is going to court. I cannot see how, given the stakes that are at interest, that this matter is not going to land up in the court. For me, there are two questions that are related to this. The first is, which court is it going to go to? So is it going to go directly to the Constitutional Court in terms of Section 79, or is it going to start off as a challenge in the High Court if an interested party brings it in terms of Section 38. I actually think that the second would be a preferable route to take, purely because you would then have the High Court who would be able to consider the act, and it would then, the bill, or at that point it would be an act before it gets to the Constitutional Court. The Constitutional Court has said frequently that it prefers ordinarily to hear matters that have been deliberated upon by other courts. Obviously, Section 79 creates a different process to that. The second question is, what bill is going to land up before the Constitutional Court? So if the President signs the bill, it becomes an act, and then that act is challenged, then it's the bill in the form that was passed by Parliament. It's quite possible that if the matter were to be sent back to Parliament by the President, you would have a different bill, and that bill would still then be challenged. And so what you might land up with is a watered-down bill, which then still gets to the Constitutional Court, and if it survives scrutiny ultimately in front of the Constitutional Court, we'll then never know what would have happened to the provisions that had been watered down, or in their original form. So you might land up with certainly from the perspective of access to learning materials, from the perspective of socioeconomic development and advancement, you'll land up with an inferior product that could have actually been something much stronger had the bill in its current form gone to be tested. And so it does, at least at that level, seem to make significant sense that what you want is that these questions, which have been deliberated upon for years, and were deliberated upon in Parliament, in both before the National Assembly and in the NCOP, that those important questions do go up to ultimately to the Constitutional Court for a determination one way or the other, rather than taking it back to Parliament to see who blinks first. A couple of points I want to make on the President's powers and what the President can do and what the President can't do. And then one of the topics that I was asked to deal with was on just identifying the issues. There's already been some discussion of what the contentious issues are. I'm sure most people in the room know, but just to highlight those, and those will then be form the subject matter of panels that follow ours. So a point that has been made, but I think has to be stated over and over, and that is that the President has no power to decline to assent to the bill on policy grounds. The place for the policy debates, that has come and gone. That was in Parliament. And so the question that has been raised, and I think it was raised a couple of weeks ago by a DA member of Parliament, was this question of the threats that are coming to lose certain trade status, and the threats, the pressure that is coming from the United States government, whether accurately reported or not. Now, even if that is so, even if that pressure is being placed, it is not a consideration that the President is constitutionally entitled to take into account. If the considerations raised by any party go to have a source in the Constitution, and the President is convinced that there is that provisions of the bill are unconstitutional, linked to those concerns, that would be a basis for sending it back. But purely a policy ground does not go far enough. The second, and we've heard, this has also been the subject of that same media piece and other submissions, and that is concerns about compliance with international obligations. Now, once again, that is not a consideration for the President to take. There are arguments that and I would say very strong arguments, that what the bill seeks to do is in compliance with South Africa's obligations, particularly under the WTO agreement on the trade-related aspects of intellectual property rights, and other international agreements dealing with copyright. But even if the bill is not in compliance with international obligations, that is not the test that's before the President. The President has to consider whether there is a violation of the Constitution. Now, there is an interesting interplay between international obligations and the Constitution. And most interestingly, I would say, would have been in the Glenister judgment. But ultimately, it's not about non-compliance with an international obligation. It's about non-compliance with the Constitution interpreted in light of international obligations. And that is a substantively different test to take. So what then may the President consider? The President can consider substantive questions, procedural questions, so the question of whether the bill was correctly tagged, whether it should have been a 75 bill or a 76 bill. But importantly, what the President has to do is that if the bill is to be sent back to Parliament, he has to identify his particular constitutional concerns. So even if it goes back to Parliament, it is not a wholesale return for the entire process to be reopened. So subject to one caveat, I'll come to that. But the President has to identify and has to say Section 12A, for example, is problematic for these reasons. And that has to be set out. And then that is what then goes back for deliberation. Nothing else. We're not going back to start the process again. A complication would come in if the President were to form the view on the basis of legal advice given to him that the bill was incorrectly tagged. That then would have to go back and would have to follow the correct procedure, and that would then raise the different process would then open up for quite a significant and potentially lengthy consultative process involving the provinces. I think it's important to recognize that the President is not here playing the role that is given to the courts. The President is not given a power to make a determination on whether this bill should stand or not. It's a power to. What he needs is a genuinely held, well-grounded view that either certain provisions of the bill are unconstitutional, or that the process in terms of which it was adopted are unconstitutional. So, what then are the substantive, or the issues that are in dispute? Mention has been made of various opinions. I'm only aware of one opinion and one set of submissions, and I think it's important just to distinguish between the two. Just to come clean, I'm one of the authors of the opinion that was prepared for Recreate that has been relatively widely distributed. What we worked on were submissions that industry made to the National Council of Provinces. And a point we make in the opinion, I'm not trying to downgrade the value of what those other advocates, of their work, but they make it very clear in their submissions that they are making submissions on behalf of their clients. That is not a legal opinion per se. So there are really three primary areas of concern. The first is the question on tagging. And I think that is going to come up a lot more in later discussions today. And really that, just to put it, I think, into simple language, if it follows a certain procedure, if it follows the Section 75 procedure, which it did, then as the keynote speaker mentioned, the role for the provinces, it doesn't go to the provinces directly, it's done through their representatives in the National Council of Provinces. If it's a Section 76 bill, then there is a much more extensive consultation process that takes place in the provinces. Then the second set of issues are the concerns relating to Sections 6A sub 7, 7A sub 7, and 8A sub 5. And those are the provisions which which allow for contracts that were entered into in the past. Well, it deals with the share in royalties for authors, whether in relation to literary or musical works, visual artistic works, or audio visual works. And in respect of those provisions, there are two issues that have been raised. The first is the issue of, well, three issues. One is of retrospectivity, then of alleged arbitrary deprivation of property, and then thirdly, an issue raised in relation to alleged impermissible delegations of power. That's the power that is given to the minister to make regulations. Now, the way I understand that power is that it's a power to make regulations dealing solely with the process, in terms of which any person who is not able to reach an agreement on a reasonable royalty is then takes that matter to the Copyright Tribunal. So it's purely about the process in terms of which that dispute can be resolved. What the bill does, and it's quite interesting, it has been done before by Parliament, but it's particularly interesting here, is that it's a regulation-making process, which then also places an obligation on the minister to conduct a feasibility study, and then to take that back to Parliament, where Parliament then has to approve the regulations. These added elements, ordinarily regulations would just be made by the minister. They wouldn't go back to Parliament. These added protections have been seized upon by those opposed to the bill as a way of somehow saying that these delegations are impermissible. And then the third set of concerns are the concerns relating to primarily to Section 12A, dealing with fair use. What is interesting, in respect of fair use, there are three different areas. Firstly, an allegation of inadequate public consultation. The second, again, is the point about arbitrary deprivations of property. And then there's a point raised about the alleged violation of the right to freedom of trade, occupation, and profession. These submissions were made in the National Council of Provinces. So it's not as if they've never been heard before. They were actually an essential part of the lawmaking process. So even the concerns about inadequate public consultation on the revised Section 12A and the move from fair dealing to fair use, and in particular the move away from a closed list to a list which allows for other examples other than those expressly listed, that concern was raised and debated in the National Council of Provinces. I think my time is up, or I think I'm, as they say in the Constitutional Court, I'm in injury time already. So I'll leave it there, and you can pick it up in the Q&A session. Thanks.
Thank you, Jonathan and Justice Yacoob. Now we're going to take a few questions. Please, if you're given an opportunity to ask a question, ask a single question, because we can try and accommodate as many people as possible. In the interest of time, because we start a little late, I'm going to take 3 questions. You can address your question to one or both of our distinguished speakers. And once you've heard all 3 questions, I'll give them a chance to comment. And if nobody asks a question, I have plenty. So. Who's our first questioner? Please go ahead, sir. Can you please speak into the microphone?
Hello. Oh, thanks. My name is Basil Dube from the SA Lawyers for the Creative Arts, which is now newly established. You'll hear more about it. Since we have the bill now before the President, my question is there any legislation that determines the President either signs now or not? So is there any determination by legislation how long should the bill be with the President? before it could be signed. Thank you.
Thank you. And please do as the questioner kindly did, which is to introduce yourself. Next question. All right, well, I'll get the chance to ask my own question. Oh, no, Professor Jazi.
Thank you. This is, I think, a question for Advocate Berger about the you mentioned earlier the potential interplay between international standards and domestic constitutional analysis, and I wondered if you could expand on that point.
All right, third question. If the President sends the bill back and it's amended, is it possible to challenge the amended bill as not having followed the correct constitutional process? Could the Constitutional Court weigh up whether the President in fact had an appropriate set of concerns? So would it then dog the legislation? Would it always be subject, if it gets sent back, would it always be subject to challenge on the grounds that the President shouldn't have sent it back? Thank you. Justice Yacoob, if you'd like to start first, and then Advocate Berger.
All right. To take the last question first, if when the amendment by Parliament of the bill results in its arguable unconstitutionality, then it will be possible to take it up on the basis that the bill is now unconstitutional. If Parliament had left it as it was, it would have been perfectly compliant with the Constitution. Those are the limited circumstances in which that can be taken up. And then the second to last question is that our Constitution is different from everyone else's because we have to have regard, our courts have to have regard, and the President too has to have regard to international law in making a determination. And where, in our constitutional dispensation, it is possible, for example, to interpret something consistently with international law or inconsistently with it, the courts and the President must go the route of interpreting it consistently with international law. Where there's the choice between upholding international law and not upholding international law, make the choice of upholding it. And just to give you a single example, there's a case in which our courts had to decide whether a soldier is a worker. Quite a complicated question, you might imagine. But we relied on the pronouncements of the International Labour Organization and to many international treaties to come to the conclusion, controversially, but we had no debate about it. The judgment was unanimous that the soldier was a worker. So we have regard to international law. We take international law very seriously, and the Constitution gives the injunction that that is the way in which it is to be done. The first question I'll leave to Jonathan.
Thanks. The first question, there's not, it really is a, I think one can ask the question, how long is a piece of string? The President has to make a decision within a reasonable time period.
Diligently and without delay.
That's Section 237 of the Constitution.
Yeah.
Arguably, he's way past that time. I mean, not even arguably. I think it's quite clear that he's way beyond that, given when this bill was referred to him. We've seen again, quite recently, in response to another contentious bill, the Traditional Leadership and Khoisan Act that just got assented to. That also, I noticed it's Act number 3 of 2019. It was sitting there for a long time. So there's nothing that says within 30 days or 60 days, but certainly it has to be done without delay, and the delay has already come and gone. I didn't quite understand the third question, and I'm not sure if there was anything in relation to, I think you spoke about tagging. Was it not? Oh, because what would happen if a bill, if the bill's correctly tagged, but the president sends it back because it was incorrectly tagged, and then it goes through an entirely new process, results in a new bill that a different set of people are unhappy about. And I think arguably based on the free legal opinion we got from Justice Yacoob, arguably we should then be able to challenge it on the basis of an incorrect tagging, if that was the process in terms of which it finally went through. So it doesn't really matter on what basis. Just on the international law question, which luckily was answered for me, I just want to read one quote from the Glenister judgment, which deals with the interplay between international law and our constitution, and that's outside of the context of an alleged violation of the Bill of Rights, where the court said as follows: "We therefore found that to fulfill its duty to ensure that the rights in the Bill of Rights are protected and fulfilled, the state must create an anti-corruption entity with the necessary independence, and that this obligation is constitutionally enforceable." And then this is, I think, for me, the very important part. "It is not an extraneous obligation derived from international law and imported as an alien element into our constitution. It is sourced from our legislation and from our domesticated international obligations, and is therefore an intrinsic part of the constitution itself and the rights and duties it creates." So it would have to, the international obligation would have had to have been incorporated into our law and into our constitution for that then to raise to the level where the president can rely on that. But merely to say that the fair use provisions, for example, go beyond, I think it's Article 13 of TRIPS, that is not a sufficient ground upon which to send it back. That's not a consideration. It may well have been a consideration in Parliament originally as a basis upon which to look at that provision, but now it's not a basis to send it back.
Thank you both. I'm sure there are many more things we could discuss, but that's all we have time for right now. Thank you, guys.
Okay, we've got to go. Let's go. Start.
Thank you, Justice Yacoob, very much. Thank you, Kate, and thanks, Andrew, for moderating this session. I've learned a lot about the Constitution and actually where we sit and how the president should think. So just for quick few minutes, I want to give an opportunity to recreate to the coalition and perhaps to the American University. Sean, is Sean here? Just to make some remarks. I know coalition didn't come as a group, but I know you don't have to be a member of the coalition, but even if you hold the view that the president should send the bills back to Parliament, you may also get that opportunity to just vent out what you think. Thank you. Can I begin with Sean? Recreate Ben Cashdan. Okay.
Thanks very much. Please time me and tell me to shut up when I've said enough, because I could say a lot. It is really refreshing to hear Comrade Fubbs next to me speaking so frankly now that she's no longer in Parliament. Sometimes when she was in Parliament, you had to read her mind to know what she was thinking. Now we know what she's thinking after having dealt with this issue for so much time. Luckily with Justice Yacoob, he never really beat about the bush, and you always knew what he was thinking, even when he was on the bench. Well, as a private citizen and a founder of a civil society organization, Recreate, we don't have to beat about the bush at all. We can call a spade a spade. And that's what I intend to do. Of course, we are a coalition of filmmakers and photographers and education activists and disability rights activists and IP injustice activists. We've just linked up with the Treatment Action Campaign and had them come and join our ranks as those who fought for affordable medicines in the 1990s and now see this fight as a continuation of that fight. So we're excited to be united and for many of us to be here. We watched collectively the ANC in Parliament putting together this bill as part of its vision for a fourth industrial revolution, an economic change in South Africa to get with many changes in the global economy. And although we're not always fans in civil society of structural adjustment, we are fans of this vision. We would add that we want the ANC to ensure at all times that it's an inclusive fourth industrial revolution, not just for the sake of digital technologies, but for the sake of people and their involvement and their empowerment to use digital technologies. But with that in mind, we think the copyright bill is an essential piece of legislative reform to make an inclusive fourth industrial revolution possible. Now, like any economic reforms, it comes with adjustment. It comes with difficulties. As Comrade Fubbs said, it's time for people who have fears not to stand in the way of the process, but to make the adjustments they need to make. When, in line with the similar vision for energy, the ANC originally proposed an energy mix based largely on a transition to renewable energy. There were those in the coal lobby, there were those in the nuclear lobby who fought back and said, no, we don't believe in a progressive move forward. Unfortunately, in that particular case, there were a few people in the leadership of the ANC who seemed to be captured by that nuclear fight back. Luckily, they were defeated, and we luckily now, I don't know whether it's all luck, but with the wisdom of South African voters and those in the ANC who brought about a new leadership in the ANC, we now have a move to put aside that nuclear fight back and move forward with a just transition to renewable energy and energy mix. And I think the trade unions are even coming on board with that. Well, in the case of the information economy, the knowledge economy, that's what we need. We need everybody to get with the program to a reform towards an inclusive digital economy where everybody can draw on our cultural and information heritage and we can all be part of the future. There will be those who stand against the changes. Justice Yacoob, you called them the racists and the publishers. I think that's not a bad shorthand summary. To be a little bit fairer, we might want to call them the racists and the entrenched intermediaries, such as some multinational publishers, because I think it is proven around the world, publishers in general don't suffer when you move to a more inclusive digital economy, but there are adjustments to be made. Royalties paid out of hand by universities to entrench multinational academic publishers, that becomes a problem. That's an adjustment that we need, that we want to see made. The ANC government is committed to it. The trade unions, SADTO, are committed to it. Denise at Wits needs it urgently to afford learning materials for her students, and we just need that to happen. When it comes to writers and authors and publishers more broadly, just as the Canadian experience teaches us, there's money to be saved from royalties paid to multinational publishers that can be plowed into the local content production industry. So it's actually a benefit for the local economy. We are too smart to be told to hold back from the vision we need by anybody, whether it's Vladimir Putin with his nuclear lobby, or whether it's the Motion Picture Association of America in cahoots with the US trade representative and its rather outrageous political pressure being placed on our body politic. And I would say, if there is indeed a representative of the US Embassy here, please take a strong message with you today, Sora, madam, wherever you are, whoever you are, from South African civil society. We will not be told how to organize our economy for the benefit of our people by the United States government or anybody else. You have fair use in the United States. It's a supreme hypocrisy that you don't want us to have it. You develop your creative industries with it. It's a supreme hypocrisy that you don't want to have it. And we're too smart for that kind of trickery. We've been there before in the 1990s when we had to fight the global pharmaceutical industry, backed by the governments of the United States, the government of Switzerland, and a few other regressive forces in the world. And we said, it's a bluff, guys. You'll go on doing business in South Africa. We're too big a market for you to ignore us. You'll go on doing trade. And what happened? Pharmaceutical prices went down. We passed our legislation, a little bit similar to the legislation on copyright now, with exceptions and limitations to patents. And millions of people received the medicines they need. No companies pulled out. They adjusted their prices, and life went on. So please don't bring your threats here, we say. The last message from Recreate is, this is not about bleeding heart liberals and activists saying, help us with access to learning materials. We're disability rights activists. We are communities who are impoverished. It's not that alone. It will help with all of that. The bill is great for those constituencies who haven't had access to learning materials. The bill has a very unusual provision that doesn't exist in other copyright bills. It's path-breaking in the world, which is against price gouging by publishers. It says, publishers, beyond fair use, if you don't make a very important textbook that our learners need available at a price which is reasonable, we'll copy the whole book. That's something that's not in much similar legislation around the world. It's pioneering by the ANC legislators to put that in, very brave, but it's a great provision which we hope other developing countries will follow, because it says to the publishers, it puts them on notice, you want to charge 500 rands, 1,000 rands, 3,000 rands for a textbook that the majority of our learners need, you're making a mistake. You're only going to be selling to a tiny little privileged elite. We want to put you on notice that if you do that, we'll copy your book under our new legislation until you reduce your prices, and then we'll start buying the book. Exactly the same as generic medications. So the final message is that this legislation is good for growth, exactly in opposition to the scaremongering that has been brought our way by those who say it will harm publishers, it will harm industries that rely on creativity and tech. That's nonsense. All the evidence in the world is that when you open up exceptions and limitations to copyright and to patents and IP generally, you have a more dynamic creative sector. One expert in this, Ruth Okadiji from Harvard University, has estimated that $3 trillion worth of investment goes into those industries around the world that benefit in part from exceptions and limitations to copyright, because you can take a Disney movie and turn it into a fan page and create a whole new industry around fan pages. You can take a Disney movie, change a few characters, and come up with an African video game that no one had thought of previously, noting, of course, that Disney probably stole its characters from Africa in the first place anyway. So there's a bit of claiming back going on there. So let's call a spade a spade. Time for this copyright amendment bill. We can have legal experts, 1,000, and we've hired a few at Recreate in our time to look at technical issues. But all the tagging issues, all the deprivation of property, scaremongering, it's all a red herring by those who would have us defend their entrenched interests and oppose forward movement to an inclusive creative and tech industry. So we say thanks to the ANC visionaries who put this bill on the table in South Africa. It's time for President Ramaphosa now, please, to sign it this week. Thank you.
Thank you very much. He did warn you that my timekeeper, he should actually manage time. But I think we're doing quite well. We're running a little bit behind time, though. Can I call for the next panel, moderated by? No. There's nobody from the coalition, and because of Ben has taken all the time, so I think we're doing quite fine. So can I call Nontando to come and moderate the panel on limitations and exceptions? Thank you very much. Let's give them a round of applause. Thank you. The panel program, Mr. Christo Ditlek from Blind SA.
Hello. Okay. Before we call the panelists, I'd just like to do a brief introduction and just state that, as Joan Fubbs mentioned earlier, a lot of controversy surrounding the bill comes predominantly from the limitations and the exceptions in the bill. So, to best equip everyone that's attending this Indaba today, we thought let's hear from stakeholders who actually have vested interests within the copyright limitations exceptions, be it that they are for them or they are against them, but this is the opportunity for them to have a discussion with everybody present. It has been noted previously earlier, but I'd like to state again that members of the coalition who have problematic issues with certain limitations and exceptions did decline invites to attend and to speak on the panels, but I do know some of them are sitting in the audience. This is a friendly and open space. Please do feel free to contribute when the time calls. The whole point of the Indaba is to break the impasse, so we do want to hear the pros and the cons, the arguments on both sides. Before I call on the rest of the panel to come forward, Dr. Leti Kleyn actually has some sort of she has a presentation that goes alongside her part in this panel discussion. So I didn't want any of the panel members to be sitting here and be deprived of viewing this. So she'll kick it off for us.
Good. Good morning, ladies and gentlemen. Thank you very much for the opportunity to speak about something that I am incredibly passionate about, and that is publishing, scholarly publishing, as well as the situation within academia with regards to access to information and knowledge resources. And I think the one thing that really irks me at times is the fact that this whole bill is so incredibly convoluted when we start to speak about issues. We actually need to untangle them a little bit, because when we come into the same room and we talk about books, we talk about school textbooks, we talk about university textbooks, we talk about a variety of issues that are non-related to each other. Now, I do know that all of these little things is like a spider's web, where if you pull one of those little, it's going to have an effect or a ripple effect somewhere else, because that is the way that the bill has been designed. But I want to give you some information and some background as to how I make sense of the situation surrounding the publishing industry, specifically with regards to higher education and training. So please don't read ahead, just follow me as I go through these with you. What I've done is, as a systems theorist, I really want to understand what's going on and what the different elements would be and the different role players. So what I've done is I've divided it into 4 categories. The first one is the school book market. The second one is the tertiary prescribed materials. The third one is the scientific societies and the journals that they produce, as well as the South African university presses. And then on the side of libraries, in terms of supplying teaching and learning materials. So with regards to the school book market, and I'm not going to speak about that today, but that's a completely different case in point, as a very large percentage of school textbooks are paid for by the government and supplied to schools. We also know that the department has a lot of problems with regards to tenders, getting it delivered, getting it in the right language, getting the right materials out. In some cases, in some schools, children are also obliged to buy their textbooks, so it's not as if all textbooks are free. We also know that President Ramaphosa said in his opening address that, or actually in the State of the Nation address, he said that we are moving in an electronic era, government's punting for e-learning, that they have digitized all the materials, which I thought would drive everybody insane because I think he meant digitalize. He definitely didn't scan all the textbooks. We know that the coding curriculum is being rolled out next year for grade 4 to grade 7 with regards to his vision for the fourth industrial revolution related to sustainable development. The parts in red are some of the problematic issues. So what we know is that at the moment there is an ongoing investigation into price fixing with regards to PASA. And also, just to not leave that part out, the school book market as well, that's government funded, also includes the TVET, the materials used at TVET colleges. All right. So let's then move to the not so difficult one, which is the scientific societies and the journals. What they do is they mainly survive by membership fees and page charges. They are not profit driven. They are often non or partially subsidized by the host, which is normally a university. And the same goes for university presses. They are also non or partially subsidized by the host institution. They have a business model in which they need to provide profit so that they can continue with their work. There's an element in certain disciplines like the humanities and the social sciences with regards to collaborative work and monographs and so forth, where the focus in these fields is actually on the prestige of the publisher. In red again, the interesting part is that the DHET has changed its policy on book subsidies. So in the past, the university would receive 1 unit, which is about 120,000 Rand, for a book publication. That has now been extended to 10 units as a maximum, which means if you now produce a book, your university can get up to 1.2 million Rand worth of subsidy. And that starts to change the picture a little bit, because maybe we can then say, we're going to take a little bit here and we're going to invest there. So with regards to the tertiary and described material, the textbooks, that would be the academic publishing sector. So that would be local, international, or hybrid. And hybrid is those, what I call hybrid, is those publishers who are actually international publishers, but who have offices in South Africa, like, for instance, Oxford University Press and so forth. So we know that government also supports the buying of textbooks for students in the tertiary environment through the NSFAS bursary system. We also know that students purchase either online or through the booksellers. We also know that we've seen cancellations of subsidized textbook for developing countries by some publishers after the case of the Malaysian student as a form of punishment, I think. The debate that has been going on about the high prices of textbooks for at least, or I think at least a decade with regards to trying just to look at reducing VAT on textbooks or not charging VAT for that. So that's a discussion that's been going on forever. What I think is important when we look at this is to determine what percentage of the material that is used within the higher institution sector is actually international or hybrid textbooks, because that's money that leaves the country. Then you have international publishers who develop pretty fantastic platforms that goes often with a print book, as well as an electronic version of the book, as well as a unique code that the student can log onto a platform where there is a variety of additional materials in terms of blended learning and so forth that will help the student. It also helps the lecturer because there's a variety of already made tests and things that's set up that's automated by that. What are we doing in terms of the development of new, usable and sustainable blended learning developments? Or do we still remain in the era of just producing textbooks? And what's really interesting about the international way is that Wiley said that they can sell in bulk to a university if every single student gets that book, package, parcel, whatever, at a 60% discount. They make still more money than what they would from students having to buy it through trade. So that, yet again, is another different element that we have to think about. And then we have the copyrighted works that goes into course packs and that we pay DALRO for. So it's actually not the university that pays for the copyright, it's actually the student. So it's either included in your course fees, or if you study at a university like the University of Pretoria, it's an additional line item on your student bill when you get it. So the student pays that. And just to give you an idea, that her colleague and I conducted some research, and we received responses from 16 of the 26 universities that indicated that we paid close to 32 million rand in 2018 with regards to DALRO fees. Okay, then we move to the one that I think is the most controversial and difficult, and that is the teaching and learning resources. So in the research that my colleague and I conducted, we discovered that we paid close to 1 billion rand in 2018. Those 16 of the 26 were close to 1 billion rand for access to books and electronic resources, of which electronic resources is about 80% of what is bought with that money. The problem with this is that we sign non-disclosure agreements, so we don't know what we pay, and it cannot be made public. So it's incredibly difficult to figure out who's paying what. We now know that 80% is, well, an estimation of 80% of library budgets goes to international publishers, and that's what we call the Big Five, the monopolizers in terms of electronic resources. And globally, 84% of the money that these institutions make actually comes from the higher education sector. That's the international standard, 84%. Okay. So there's also a sense for me of double payment when it comes to DALRO materials. Because if you already bought the textbook or subscribed to the platform or the service or the database of information, your student has access to that. If you want to take a chapter from that book, the student can go into the library and legally make a photocopy of that chapter. But if you make it in bulk, you have to pay for it. So what's happening now also is that we get less and less students using course packs or universities using course packs. Now there's a push for a linkage fee, which means that the student will now go onto the Sakai or the Blackboard system for his module. There would be a link that he would click on that would take him to the subscription package of the library where he needs to put in his password and his username and will then be directed to the actual article that he needs to read. Now the request is every student must pay for that towards Delro. Why do we pay? Why do we get a subscription fee then? What do we pay for that if we want students to pay again to access information that they anyway have access to? On the positive side, we've seen the open access movement, but that's a little bit, I think, unstable at the moment. So we've also seen double dipping with regards to the researchers who publish. We have contract law challenges, as indicated. We have the issue of article processing charges with regards to it being too expensive. We have one national and one international initiative going on. The one is the proposed DHE business model that also links closely with the international model for Plan S, which I don't have any real hope for. But okay, so let's say we take this system and we put it in a bigger system. Okay? The first one is the political situation. Okay? What does the minister want? The minister wants knowledge production as well as knowledge use. He does not want South Africa to be a country that just uses other people's information. He also wants to drive information, make sure that we make a contribution towards that. What does the president want? The president is gaga for the fourth industrial revolution. Okay? And for sustainable development. But what we also know is that the fiscus is empty, or very close to empty. So corruption is an issue, the tender process with the books is an issue. So it's not an easy landscape to maneuver yourself in. And these things will also have an impact on higher education institutions. The second one is the social one, where students would say that they struggle to get access to information, but I'll explain it a little bit later. It has also become a human rights issue, where people say, open up the information on Ebola and Zika. Why are you selling it when we are having the need for that information now? And what you would see with some of these bigger publishing houses is that they would open up their database of that information for a limited period of time, which is actually for me a confession of saying we know that we are holding back as to what can be achieved. The economic sector, with regards to Harvard University, in 2012 already, they indicated that they cannot afford subscription fees anymore. And just to give you an idea of how these subscription fees work, it's a little bit like your DSTV package. So you buy a big deal, and inside that big deal there might be 5 or 10 or 15 journals that your institution actually needs access to. But then you also get 100 second-rate journals that's also bundled together, and you can't unbundle that. And the big problem is that the library does not own any of the material. So if I talk about R1 billion, I talk about leasing every year for R1 billion and raising and raising and raising. So if you cut your contract, you lose access to the information that you've had. So it's a leasing agreement. We keep on paying for the same materials. Okay, so 2012, Harvard already indicated they can't do it. Interestingly enough, everybody would say that Sci-Hub is the one that's going to cost publishers most money. Wiley has determined that their revenue is influenced largely by ResearchGate, which is not a repository system, which is a social media site. Okay? The Wellcome Trust, as well as the Gates Foundation and a variety of other funders, have indicated that you will publish open access. So the funders also do that, and then also with regards to the APCs. So then there's also the institutional element with regards to, we want to also jump the fire hoops. We want to be ranked. We want to be a ranked university. So we want to publish in international journals. So we adapt our research to publish in international journals so that we can get the credit for that. Well, it's actually not really relevant to the country as a whole. Africa produces 1.1% of global scholarly knowledge. In some cases, the statistics will tell you it's as low as 0.6%. And also, we want the taxpayer to get value for their money that they spend with regards to injecting into the system. And then there's obviously the legal aspect. So what we can't avoid is the fact that we're going into a technological era, all right? And if we want to figure out what on earth, how are we going to untangle this and get this right? Because we do know that the prediction is that there will be between 14 and 24% job losses in the knowledge creation industry already. Okay, so that's going to happen whether or not the bill passes or not. When we look at the political elements, we want a knowledge economy, we want knowledge equality, but we also have policies that speak like this, and that does not align with legislation. So the DSI has a framework for open science, but yet we don't have the legislative power to actually get to enforce that. When we talk about the social issues, for instance, we talk about a generation that's digitally born. We talk about set behavior that has already been indicated by the research done by Laura Czarnowicz and Eve Gray, where they asked students, do you know what is the meaning of plagiarism and what is the meaning of copyright? Where everybody most knew plagiarism, and almost nobody knew what is copyright or how it actually functions. We also have, within this context, in the social context, students sleeping on campuses because they don't have travel money, not properly eating, so access to food, violence, gender violence, a variety of other issues with regards to that. Your academic culture needs to change. It's not about the rankings. It's not about the subsidy. You don't have to sign over your copyright to an international publisher so that you cannot prescribe your own work that you have produced for your students without them paying for it. Economically, for me, there's a big link between economic and legal, is that we are being held hostage by these 5 big publishing houses. They are monopolizing us. It's, for me, sometimes a question of recolonization, in a way. And the important thing that we need is the legal reform that will enable us to move forward. Thank you very much.